Before this case even begins, take a second to understand what's really on the line here. We're looking at a landlord-tenant dispute that quickly turns into a full eviction hearing, with unpaid rent, partial payments, disputed utility charges, and a tenant fighting to stay housed. On one side, the property claims months of broken promises. On the other, the tenant says illness, unexpected fees, and financial hardship pushed everything off track. This is exactly where courtroom reality collides with real life, because sympathy doesn't erase contracts, and explanations don't always stop eviction. Watch closely how this unfolds, because every detail matters.
Are you receiving any assistance from Waco Housing Authority where they pay so much of your rent for this property?
No.
So we have a lease agreement with Miss Reynolds from August through July from August of 2025 through July of this year. She didn't actually move in until September, it looks like, at which she made her full payments and was able to have a zero balance. She paid for, August and September's rent and was able to move in. Since then, she has not had a zero balance. That was the last time she had a $0 balance. She's made small payments of $460, $630, $900, but it's never brought her balance down. So right now she owes $1,250, and that's just in rent. Her monthly rent is supposed to be $625 a month. We have called her and she's promised to pay several times. It's just never enough to get caught up. And there's no real guarantee that she's going to get caught up. So, when she had said she was going to pay in full several different times, and then we never got payment in full. So we gave her the 3-day notice. We placed it inside, taped it inside her bedroom door. And I have not spoken to her since that.
Right here, the landlord lays out the financial picture clearly. The tenant paid August and September in full, then never reached zero balance again. Small payments came in, $400 here, $600 there, but not enough to catch up. That's important because in housing court, partial payments don't reset delinquency unless they bring the balance current. Promises to pay don't count either. What matters is whether the rent was actually paid in full. And once a 3-day notice is served, the clock officially starts. This is usually the moment when cases either resolve or head straight to eviction court.
What happened?
We signed the lease in August. Is that
Yes.
correct?
Yes.
All right. Anything else before I move on to the defendant?
Nope, that's it.
Ms. Reynolds, you've heard the case against you. Here's your opportunity to defend yourself, man. Go ahead.
Okay. So yes, I did move in late because I was supposed to be getting a 1-bedroom and 1 bath, but I ended up being put in a 5-bedroom and 5 bath. So I wasn't like expecting to be in a big unit like that. So that's why I moved in late. Okay, I got sick, so that's why the income started getting short, and then my rent started, like I started carrying late fees because I wasn't able to pay on time because of the illness I was going through. But I have been trying to reach out and to them, like calling and sending emails to try to work something out because even when it was incorrect charges, I was freaking out about that because they brought me down too. So I was trying to get assistance, but I was waiting to hear back from people to get assistance, but they didn't have money to help, or it's just like I wasn't qualified to.
Now we hear the tenant side. She explains that she expected a 1-bedroom but ended up in a much larger unit, moved in late, then got sick, which affected her income. She also raises concerns about utility charges that confused her and made things worse. Situations like this happen more often than people realize. Illness, unexpected costs, and housing transitions can snowball fast. But legally speaking, the court still focuses on one central question: was the rent paid on time? Emotional circumstances matter, but they don't automatically cancel lease obligations. Let me know in the comments, should hardship change how eviction cases are handled?
Get assistance.
Okay. So I want to make sure I'm hearing you correct. You initially signed a lease for a 1 bedroom, but you ended up moving into a 5, but you're only renting one room, right?
Yeah.
Okay. And you fell ill. Uh, Late fees started accruing. You just couldn't get caught up. You mentioned some about incorrect charges. Tell me a little bit more about that.
Um, I guess I don't know really what happened. I like I know I was what I had paid and what I owed, but when I started seeing like extra fees, like I was trying to see where it come from because she when I emailed she did list it like the fees, like the water and all that, but I was seeing some extra. So I spoke out, but they said it was correct. But it really wasn't. Like a week later, they sent the email saying about incorrect charges.
So they resolved the charges, meaning they added them, but then they
Yeah, I'm sorry.
so that they said they added them, but did they take the charges off after they found the correction?
I think something like that, a reimbursement.
Okay, so the question is, did they resolve the issue that you had with the charges?
I don't know because like they already had the time that they did resolve it. I think they already had like issued the eviction notice out. So like I don't know if they fixed it before then or was it the same day or it was later.
Can you tell me which charges you're talking about? You defend
Uh, I took my phone, I had screenshotted it
you also
because I have the paper with me.
should have received a ledger whenever you were served by the constable. Did you receive that copy of the ledger?
Yes, but I don't have the paperwork on me at the moment because I'm not there at the apartment.
Yeah. Are you still staying there? Are you still staying at the unit?
Yes, I'm still,
Okay.
yeah, I'm still staying there.
Here's where things get technical. The tenant tries to explain the utility reimbursements and extra fees, but she doesn't have her paperwork in court. That's a major problem. In eviction hearings, documentation is everything. Screenshots help, but ledgers, receipts, and official statements carry real weight. The judge starts sorting through what were charges versus reimbursements, but without clear records from the tenant, it becomes hard to prove that utilities were the true cause of the missed rent. This is a powerful reminder. If you're disputing charges, always bring your evidence into the courtroom.
I'm not there at the moment. Okay, so it was just supposed to be like three, I guess, like the water, electric. Well, not even the electricity. I think they were supposed to be separate, but it was supposed to, like, she told me the reimbursement or the fees that was showing was just supposed to be for, I guess, water, electric, and sewer. So in December, I end up seeing like, let's see, because 109, the 20, 2154, 2093, 2194, and then 1413. So those, like when it was showing like utility reimbursement, um, it's just like where right now with the screenshot I have shown, it was like six of like the fees. So I didn't know really, what that was for. So I did ask about it.
How long have you been staying over there? Since August, right?
I moved in late, but yeah, signed up for August, at least for August.
And the reason why you moved in, was it your fault that you moved in late, or was it because the apartment wasn't ready?
Well, kind of my fault because I was still deciding if I wanted to do that. Like, after I already had originally signed for one bedroom, but it was something about a water or something. She said it wasn't going to be ready because of water or something was in the unit. I guess it was, I don't know, like damaged or something. So that's why I really wasn't going to go for it. Like did ask, can I like wait or see if one will come available for me, because like I just didn't want to be in like a big apartment like that.
How many, Miss Sansoni, how many units are at this?
There's 292 beds.
Okay, so I've heard, the case. In regards to the utilities, I do see that there were some utilities added and there were some um, concessions or things like that that were um, awarded or granted to you in regards to some of these utilities. I saw, well, reimbursements, what I'm talking about. There were some charges and there were some reimbursements. I don't believe that these utility fees uh, were the main reason why you couldn't pay your uh, and the reason why you're here today. There are some fees that are excessive, uh, according to your lease. And you, Miss Sansoni, it's a TAA lease.
Mm-hmm.
Uh, However, the lease is just a blank lease, and you all can put certain things in there, such as the rent, late fees, and things like that.
Mm-hmm.
All right. Well, one thing you may want to look at moving forward is making sure that you're in compliance with the law for its late. That's the only thing that's excessive with your lease. That's the only thing that's excessive with your lease. And I'll show you what I'm talking about.
Because it exceeds 150.
It exceeds 10%.
10% of the rent.
Because you're charging 75, then you're
That's
charging
automatically over.
15, which in our reality is $225 late fees that tenants could pay within one rental period for this particular year.
I hear you.
So that's something that you have to give with give with your people. Says, hey, I was just reminded that our late fees are not in compliance with the property code.
This moment is huge. The judge actually calls out the landlord's lease for excessive late fees, explaining that some charges exceed what property code allows. That's rare and important. Even though the tenant still owes rent, the court makes it clear that landlords must follow the law when it comes to penalties. However, notice what happens next. Despite identifying improper fees, the judge brings it back to the core issue. The tenant was still delinquent in rent even before late fees piled up. So while the landlord gets warned, the eviction case keeps moving forward.
We need to make some adjustments.
Will do.
I'm not going to go through and add up what you. All right. Were you delinquent in rent? Yes. Did you do it on purpose? I don't think you did. Things happen like you said. You fell ill, wasn't able to pay, wasn't able to get caught up. The landlord was wanting you evicted for December and January. Again, I'm not going to go through and figure out which fees were excessive, which fees were. But the fact is, you didn't pay your rent on time, even before the late fees started accruing. It's going to be a judgment against you. Again, I'm not going to go through and figure out, do the numbers. I'm just going to say for the month of January, $625. Do it like that. Plus the court costs.
And here comes the ruling. The judge confirms there will be a judgment for January rent plus court costs. Then the appeal process is explained step by step. If the tenant disagrees, she must post an appeal bond set at double the rent, totaling $1,250 within 6 days, including weekends. Miss that deadline and enforcement begins. The constable can serve a 24-hour notice, return shortly after, remove belongings, and change the locks. This is the reality of eviction court. Once judgment is entered, timelines move fast and options become limited.
They have to pay to get you. So what that means is that if you feel like you shouldn't be evicted and you want your case heard by another judge, you have the right to appeal. All right. Appealing means you disagree with my decision. In order for you to do that, you would have to post an appeals bond. In all of my cases, when it comes to back rent, I set the appeal bond double the rent. Your appeal bond is $1,250. There's a deadline for you to appeal my case. You have 6 days from today's date, counting weekends, to appeal. If you do not appeal and you are still staying there after that 6th day, then Ms. Sansoni, on behalf of the Green at Waco, can take the next legal actions against you. If it gets to that point, then the constable will serve you with a 24-hour notice to move out. It could be that next day. It could be that following day afterwards. Whenever they execute it. When I say execute it, that means that whenever they come back over there, after they're giving you notice, it could be in the mornings, could be in the afternoons. It won't be after 3 o'clock, I can tell you that. So it's either going to be in the mornings, early mornings, or it's going to be in the afternoons. They're going to knock on your door, and they're going to make you come out, and then they're going to take all of your belongings and put them outside of the apartment complete. And then they'll change the locks. So again, you have 6 days to appeal. If you do not appeal, and if you are still staying there after that appeals date has expired, that's where you'll be served with another notice. Do you understand, Ms. Reynolds?
Yes, I do.
This case shows how quickly housing disputes can escalate. The tenant faced illness and confusion over utility charges, while the landlord dealt with months of unpaid rent and broken payment promises. The judge acknowledged excessive late fees, but ultimately ruled based on delinquent rent, entering judgment and laying out a strict appeal timeline. The takeaway is simple. Hardship may explain delays, but it doesn't erase lease obligations. Documentation matters, deadlines matter, and once eviction court starts, every day counts. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns here on The Legal Watch.